tank on your property. Yeah, it's not that big a deal. A lot of people have that out here. The Otay Water District has a lot of that kind of stuff. Anyway, the preliminary report never gets delivered to the buyer. And the actual title policy doesn't get delivered to the buyer until after the close of escrow. So the buyer never sees that the Otay Water District has what's called a spill easement over their property. And the spill easement is a little different from what was explained to the buyer. As I said, the agent just sort of said, well, they've got a water tank on your property, no big deal. A couple acres, who cares? One day, Otay Water District decides to exercise their spill easement, which means they unleash, a million gallons of water over this property, and it floods the whole first floor. And here was the interesting thing. This occurred 2 years after the escrow closed. So Century 21, Cloud and Forness, even though they were just dead to rights on not delivering certain things before escrow closed, completely misrepresenting what the easement was, this, that, and the other, they took the position we have no liability because the statute of limitations is run. 2079 has a 2-year statute of limitations. They took it to court. Trial judge said, yeah, I don't like it, but I agree with it. Trial judges hate to rule on statute of limitation stuff. But he had no choice, so he dismissed it. It goes up to the appellate court, and the appellate court says, no, this isn't right. We're not going to let this happen. We're going to draw a distinction between listing agents and selling agents. Listing agents, clearly, 2079 applies. You have all the protections that I've just talked about. Sweat versus Hollister, Robinson versus Grossman, Wilson versus Century 21, absolutely. Buyer's agents, agents representing buyers or dual agents, not so fast. You have fiduciary duties. Fiduciary duties are not defined in 2079, and fiduciary duties make you have obligations that are sky high. So you might have an obligation to have x-ray vision in certain circumstances. You might have an obligation to disclose not only the fact, but the ramification of it. You might have an obligation to go off-site and pull permits and recognize the significance of those permits and recognize code violations. So, appellate court, how do we know when these things apply? Well, the appellate court didn't want to go that far, so they said, we'll take each case as it comes along. So, how do you protect yourself in that? You don't really know, because the court didn't give you a whole lot of room to go on. But what they did say is that you're supposed to be looking for red flags. And you're supposed to either identify those red flags and quell them, or if you can't do that because you don't have the expertise necessary to do it, you've got to put your buyer in a position where they have recognized it and you've at least told them what to do, who to go to, and who to see. So that is kind of how you have to approach the AVID, and that's how you have to approach your visual inspection when you are representing a buyer or when it's a dual agency, which, by the way, dual agency could mean you representing the buyer and you representing the seller, still a dual agency. You both are still dual agents. So don't think because you represent the buyer and you represent the seller that you have no fiduciary duties to the buyer. No, the whole brokerage does. So any time that there's a dual agency, you have all got to be thinking about what kind of red flags am I looking for. So if I'm going through my AVID and I'm going through page 1, what are things that I would be looking for? Living room. Well, what are you going to see in a living room? I don't know. Again, maybe ceiling leaks, maybe uneven floors, things like that, cracks in walls, signs that things have been recently patched or perhaps just patched, things like that. Now, if you're representing a seller and you're just filling out one of these things to give to the buyer, again, you only have to disclose the fact itself. You don't have to disclose what the possible outcomes of that fact are. But if you're representing the buyer, you might have to. So if I'm representing just the seller, I see a crack in the ceiling, I write down crack in the ceiling. If I'm representing the buyer in that, or if I'm a dual agent, I write down crack in the ceiling. Structural cracks can be a sign of structural damage. Structural damage can be related to earth movement, things like that. I'm not an expert in this field. I need to tell you to go and see a structural engineer and perhaps a geotechnical engineer. something like that. If I see,
That is what you want us to write down?
that's pretty much what I would want you to write down.
Wow, can you give us copies of that?
Sure. That's what I do.
Has something changed on that? Because we were told in other risk management, it was a while ago, to not jump the line of becoming any kind of an expert, only to state the facts and to say, you know, a qualified professional, buyers should seek a qualified professional, not even say whether they're licensed or anything else, you know. But to say structural and to apply those two together, that's the new thing we got to do?
Well, it's actually not that new. I mean, we've been recommending this for a long time, and then the problem is that if you don't make that kind of a disclosure, what is bound to happen to you if a claim is made against you, somebody is going to say, you may not be an expert in structural engineering, and you may not be an expert in geotechnical engineering, but you're an expert in real estate. And if you've been doing this long enough, you know that a crack in a wall or a crack in a ceiling or a crack in a floor is indicative of, or can be indicative of, some sort of a structural problem, a problem with the structure of the house. Therefore, you should be referring this person to the appropriate professional, and the appropriate professional to refer somebody to for something like that is going to be a structural engineer, or I mean, I guess you could say a licensed contractor as well. But if you don't make that next step, if you don't refer the person to the right professional, and the issue turns out to be more than simply we had some warping in the in the framing and there was a little bit of a crack. Well, no, maybe it was more significant than that. Somebody will come along and say, you didn't point me in the right direction. You didn't fulfill your fiduciary duties. If you have a buyer, for example, that is saying to you, wow, this is a great piece of property. This will be perfect because I want to buy something that's big enough to put my in-law suite on because I'm going to have my mom and dad move in with me. Well, that's a red flag, and it's not a red flag that necessarily comes from an inspection, but it's a red flag that comes from something that you've now heard from your fiduciary charge. And if I'm a listing agent and I hear that, it doesn't really affect me. If I'm a selling agent and I'm representing the buyer, it sends off a red flag, which is I better tell this person if that's what they're thinking about doing with this property, and I now know that that's an important thing for them, I better author a little letter to them saying, dude, go check this out, and go to the appropriate person and find out whether or not you can do any of this. Yeah, it's very important to state it. Start it off with dude.
Legal term.
It's a term of art, yeah, especially in San Diego. But it's one of those things where if you know that's important to your buyer, you've got to address it, and you don't want to make that decision yourself, and you don't want to tell them, wow, if that's what you're looking for, this place would be great for you because it's so big. I mean, you could put the house right over there. It'd be fantastic. No, you want to say, I don't know if you can develop this property any further than it has. I don't know if you can put a second livable unit on this thing legally. So go and talk to a contractor and see whether or not you can do that, or go talk to the city and find out, go find out what the zoning is, whether the zoning would allow something like that, or if you can get a conditional use permit or something. You had a question, then you had a question. Yes.
Can you advise them to put something like that on their buyer material issues form?
That's what you're supposed to use it for.
Right.
Yeah, exactly.
So that would be the perfect place for it.
Right. Yeah, that's exactly what that form is created for. If your buyer has certain things that they want to address, you now know what they are. You can refer them to the appropriate professional. Yes, in the back.
What about a layer, instead of saying a structural engineer, if you see a crack, say, advise them to have a home inspector. Home inspector will advise you further of more detailed inspection. I mean,
well, that's fine, except what do you do if the home inspector doesn't do that? Yeah, the only problem is what do you do if the home inspector doesn't make that recommendation? And a lot of times, I mean, most of the home inspection reports have some significant boilerplate in them that says, this is not a geotechnical